apologize for that.
All right, when you're ready.
Here's third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the first, the 6th, and the 14th Amendments.
Thank you. The record to reflect that the individual known to this court as Darrell is present in custody in person. He is wearing his jail attire this morning. I do want to make a record that at 8:46 p.m. yesterday, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open and the jurors are here and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the sheriff's department is looking into that as well, but it's my understanding based on news reports that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record. And if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information. So go ahead.
So it's being called a prank.
Per the Reddit post itself, yes.
So we don't have any ideas that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the sheriff's department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, courtroom will remain open. I'm going to be working in my office on other things and will be available, of course, if there are any questions or if a verdict is reached. So notify the parties.
Sure.
Yes.
Oh, go ahead.
Oh,
Go ahead.
I'm still very concerned about this whole Reddit thing. After having a chance to fully read it and look at some of the language that's in it. It's very concerning.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with the juror, I take that incredibly seriously, which is why I turned it over to the sheriff's department.
I would like Your Honor to, if it pleases the court, and if it pleases Your Honor, I would like to look at some alternatives. If I may bring up the in regards to the language, I also want to state that for the record, this did not come about from the prosecution side, from the defense side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information that had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
So that I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state um, the record.
I can address that for you right now if you would like.
Yeah, if it pleases Your Honor, I would like to request some alternatives to this issue. Um,
What's your specific request?
my specific request would be to look into a mistrial and also any alternatives uh, along those lines, short of that or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody. Um, and as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. Uh, so I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
Um, one being uh, United States versus Perez, 22 U.S. 579, and that specifically, I think it's referenced because that one is pretty old in itself, but it's referenced in a lot of the other uh, case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play. Um, and it specifically points to trial judge's discretion. And I think that's kind of like the leading one. Also, I looked at uh, Brown versus Rushton, 572 F.3D 198, which speaks to language is basically it speaks to the same thing. It speaks about manifest necessity. It speaks about uh, if there's an issue, exculpatory evidence, things of that nature. Um, also, United States versus Bates. That's BATES 917 F2D 388. Um, and that speaks of potential for an impartial verdict. Specifically, says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached, but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 U.S. 497, and that speaks to what I was stating before. It says neither party in the case has a right to have his case decided by a jury, which may be tainted by bias. And I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this. And certainly, you, Your Honor, had nothing to do with this. But just for the concern factor, the language uh, it's pretty clear that this, if not directly, came from a juror who sits on this panel. It came from someone who sits in this courtroom every single day. The language it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of you know, the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at. Look at some options. Look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here and these case laws and
What's the request, though, that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
Relief.
relief.
What are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know where Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website. I don't know who. Well, I think the name of the person who sent the to who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start and that the original poster was didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just said, it's an investigation going on. And if there's an investigation, then it clearly says that something is amiss. We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue was put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever it is, thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case. They make references to saying when we were in the room, they got certain feelings from where they specifically refer to themselves and a group. That would be we, plural. They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly. There's no other way to interpret this. You can tell by what they're laying out in the language that they're speaking with, that this is clearly someone close to the case. And because of that, it still has to be, I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post. It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks, and even in court days leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let it." No, this there has to be some type of alternatives, and something has to be done. Something, and if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at, if anything, to protect the integrity of the trial. I find it very hard to believe that this close to the trial being over, and all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Well, let me address your concerns, sir. I cannot make conclusions at this point about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you, though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury, and I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the sheriff's department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the clerk of court's office receive emails regarding this, it sounds like the district attorney received emails. I may have even gotten one. I don't remember the time. It was later regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it. And I simply forwarded that email on to law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited, to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. And that is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks. So go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes and he declined. So I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it is possible that the jury would need to come out. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the sheriff's department to make that available for you, should you choose.
Isn't it my choice?
Yes, it is.
So why do I need to be in street clothes? Why does that need to be on the record? That
your choice should be placed on the record. Sir.
If not, I was offered to be in street clothes. If I made it the choice.
Do you dispute that, sir?
Yes, I dispute it because it's my choice.
Well, no. Do you dispute that you were given the choice this morning? At
this point, there's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if you were to challenge that you and claim that you were required to wear your jail uniform or jail attire. You're not required. This is a trial. You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to be stated for the record?
I just indicated why, sir. So
I don't see the relevancy of it.
All right. At this point, unless there are any further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
The court declines that. I'm stepping off.
Why hasn't it been proven on the record yet? And
Okay, so this guy is really trying and trying and trying. I went to see what this whole Reddit thing is. And you know what? The judge is on point. She knew about this yesterday in the morning and didn't say anything about it. I'm thinking just to see how much truth this had to do with it. And with a case like this, there's going to be so many different pranks. He's thinking, oh, this just came up at 6:30, 7 o'clock, whatever, yesterday. I'm going to use this. His first couple words was, I am going to request for a mistrial or this or that. Mm-mm. None of that. Let me see what I could pull up for those that don't know exactly what it is I'm talking about. Let's see. Let's click over here real quick. So here it goes right here. I'm going to bring it up on the screen because I believe on everything else they took it off. Open screen. And let's get to the Reddit post. Right here. Let me see how big I can make this, honestly. Okay. Can you guys see that? Yes. So this is the Reddit post he's talking about, and it's way too long for me to read right now. I'll probably read this later on or after I take my little one to school. Anyways, I'm a member of the jury on this case. Here are my thoughts on the trial and on this subreddit. Okay, we all know the jury can't do that. So here's one of the items I believe they're looking into. And I think he keeps saying that they would have to know about the case and this and this and that because of the word jury nullification. Here's one thing that I found. I don't understand how a person on the jury can write that. Let's see. What's this one? Guys, we're looking at this together. So, not acting like, you know what? Let me go back to that other one really quickly. I wanted to see if I seen something else in there. Where'd it go? No, where'd it go? Where'd it go? Where did it go? The one that I was reading. Let's see. Don't tell me I lost it because I wanted to read something on there. And okay, here it goes. Oh, this is a partial part of it. I'm trying to see in here where it says. Clearly, she is not an impartial judge and has been belittling, demeaning, bullying. And yeah, so he's trying to use this as, I don't agree with what they're saying, you know. They're saying some mean things about you and, boy, go on somewhere, go on. Go on. That's not going to help you. We see this is another one of your little tactics. And to be honest, if she said something about this yesterday, he would have used it yesterday. But she purposely did not talk about it because she knew, who are we dealing with? Darrell Brooks? Let me not. I know I got to tell him about it sometime, but you knew that was going to be in his closing statement. That was going to run the court yesterday. So she was like, let me tread lightly on what I'm talking about with this dude. So you guys know we're all watching this live together. So the pausing is not my fault. I will just click live just to make sure we are right on with everybody else. Yes, we are. I mean, that's pretty much what I see he's doing right now. It's just another stall tactic. She knows who she's dealing with. Oh, yes, most definitely. And after this, guess what? It's going to be something else and something else. So, but she's listening to him. She's like, okay, I do hear your side. All right, y'all, let's see what's next.
If it pleases Your Honor, I would like to request some alternatives to this issue. Um,
What's your specific request?
my specific request would be to look into a mistrial and also any alternatives uh, along those lines, short of that, or along those lines, or a mistrial.
That's what he wants so bad, a mistrial due to the paper we just read. A mistrial. All right, Mr. Brooks, let's continue on your nonsense.
I was looking at some, obviously, yesterday was very, very long for everybody. If it pleases Your Honor, I would like to request some alternatives to this issue. Um,
What's your specific request?
my specific request would be to look into a mistrial.
A mistrial once again.
Along those lines, short of that, or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody. If it pleases Your Honor, I would like to
thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start and that the original poster was didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that,
Well, of course he objects.
or at the very least, request some alternatives to
Whatever, guy. What else do we have while we're waiting? I don't think I read this. Why should a juror wait 3 weeks before making a decision? That's been open court. At like 7:30, Brooks is informed of this news. Oh, okay.
And then when he put it in change of venue, I don't understand why they make him, have a trial here. It shouldn't be a change of venue. Because one is dangerous for him, and a lot of people was in their emotions, including the judge. We seen the emotions from the judge. The jury stuck her middle finger up at him. And, it just, I don't see that he getting a fair trial. And I feel like that's not right. No matter what crime, everybody that commit crimes ain't got a fair trial. So I'm not supporting what he did. I'm just supporting the process. What drove me to come.
Dude, this guy is full of crap. We already seen that the juror that he thought was the person that stuck the middle finger up, they looked into that extensively, and it's not even the same person. They even went and looked at the cameras, and it's not the same person. So this guy got to get out of here. He sure do want a mistrial so bad. No, buddy, let's not do that. Just go do your time. This guy's full of crap right here. Let's see what else we can find. Twitter. What's she saying?
Grounds to discharge the jury. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. That is how I will address it at this point. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge.
He mad at that. He want to know why she's not going to discharge this jury. He want a mistrial by any means necessary. And I'm so happy she didn't let him see this before he gave his little crying speech yesterday. Because you know that would have been added in. And he would have added all this. Well, actually, it probably would have been amusing, man. It would have been funny. Let's see. Is there anything else on this while we're waiting?
Integrity points at your integrity, Your Honor. It's alarming.
He kept trying to push, it's talking about you, it's talking about you, it's talking about you to the judge to pull out her heartstrings, but she knows this is all BS, so it's not going to work.
It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start and that the original poster was didn't think it would get that far out of hand. The way that Reddit works, the only person who can
Oh, sheesh, we can't see this. I'm going to have to get my little handy-dandy microscope. Can't see that one. Guess he's talking about his unfair treatment in jail. I'll have to take a look at that on a later note. So I'll take a screenshot of that. I'm trying to wait for the jury to come back in, so we're not just sitting here in silence. But I don't see anything that interesting. Just seeing this note. Let's see if we can see what people said about his closing statement. Let's see. Poor Darrell Brooks.
Is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it. I award you no points, and may God have mercy on your soul. What you just said is one of the most insanely idiotic things I have ever heard. At no point.
The person in the background, I don't know who this man is, but he represents all of us, this person said. Uh,
Was in fact a class action lawsuit against Ford
Objection.
for those
Facts,
model
evidence,
for
Your
those
Honor.
model vehicles.
Sustained, the juror will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know.
where's his suit at today?
That information, malfunctioning throttle bodies.
Mr. Brooks, move on.
It's information that you should have been privy to. Vehicles that malfunction and accelerate, not being able to be stopped.
Objection. That is.
It's information.
completely
It's
inaccurate.
There's an
information.
objection. Hold on. Go ahead.
Move to strike statements by.
Sorry
Mr.
for the
Brooks.
interruption.
Facts not in evidence, Your Honor, and it's complete misstatement.
Exactly. That was not what
How's it
happened
a
in this
misstatement when
case.
I have the information?
But that's not what happened to you, buddy.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case?
Oh gosh. This is a long break they got us on, but let's see what else they got for us.
Jones this morning. She's live in Waukesha with a closer look at the closing arguments and what to expect today. Hey, Amelia.
Good morning, Aaron. District Attorney Sue Opper focused the state's closing argument on the loss in the community, the 6 people killed and the more than 60 others who were hurt. Darrell Brooks focused his closing argument on the emotional toll the case has caused and that it was not intentional. District Attorney Opper highlighted why she says Darrell Brooks should be found guilty on all charges, especially 6 counts of first-degree intentional homicide. She pointed out the law states any reasonable person would stop, but Brooks never did. She worked through all of the affected parade units and says Brooks killed all 6 people and endangered the safety of thousands of others. When Brooks gave his closing argument, he took offense to the label murderer. Fighting back tears, Brooks argued again what happened at the parade was not intentional, referencing witness testimony that claimed the SUV swerved to avoid some people and was honking its horn.
He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't phase him a bit.
Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be.
After Brooks's closing argument, Opper gave a rebuttal for about 4 minutes, reiterating the state's argument that Brooks's actions were intentional. She said, quote, "Your actions are that of a murderer. You murdered 6 people. You endangered 60 others. That's not an accident." The jury got the
I think they are deliberating right now, but I thought she was going to come back and say something. I walked out to send little one to school, but I thought, well, what he was saying when I walked out, you know, him talking about the whole thing with the letter, I thought she was going to come back and say something else about it, but I could be wrong. They need to hurry up. They know they only need an hour. But if she's not going to come back and say anything, I'll just be waiting. I mean, we all know he's guilty. The only thing I think that he can have like a little bit of something on is intentional. He could have went into this rage, blacked out, and, you know, that's what happened. Either way it goes, with the death toll and the injuries, he's still, to me, with it being unintentional, he still should be doing murder. Even if he tries to make it, go say, let's say, homicide. To me, with the death toll and his lack of remorse that we see, still looking at life to me. Do we hear this one?
Law and fact, correct?
I bet they're gonna be based on whatever I'll base them on.
Oh yeah, him yesterday.
Since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
I bet they're gonna be based on whatever I'll base them on.
Well, I trust the state will object when appropriate,
Well,
if
It's gonna
appropriate.
be a whole lot of objection then because I'm gonna tell the truth. You haven't allowed. You just been making all the decisions for me, even though I told you repeatedly that I don't understand, and you still make decisions based on my behalf without my consent. Since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
I bet they're gonna be based on whatever I'll base them on.
Well, I trust the
He
state
got
will
just
object when
a smart
appropriate, if
mouth. They're gonna be based on whatever I base them on. All his little arguments are little kid arguments. Well, I'm gonna do it anyway. Yeah, so I'll just be chilling, doing other stuff. If I see other things, I might pop it on the screen. So it'll be just like you're watching the live version of it on the regular channel, but just so we could chop it up. Because sometimes it's too many people in the room. He really can't have a conversation. He has a false sense of entitlement in the courtroom. This is crazy. He acts like a big baby. He acts like anything he does is going to affect us in some type of way, and that's just not how it works.
Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I have started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves to
Mr. Brooks,
know.
this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the 73 pages this morning and into the early afternoon. I have another 30 plus pages to read. They will be informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
if
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
Dude, sometimes I wish I can see who the jury is. I could see their faces. We know after the fact we'll be able to see them if they want to speak, but sometimes I'm like, dang, I want to see who he's up against.
Under sympathy, talks about his children, talks about the hardships that he's encountered and his family's encountered. and he brushes over the loss to the community. He wants to talk about how he's never held his newborn son, never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, the Kulik family, the Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. And accuse me of practicing my closing argument. You need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it. Don't accuse me of practicing my closing argument.
Wow. That's what I say about intent. It's like, okay, yeah, you got mad, you started driving, you hit the first barrier. But then you say you're beeping, beep, 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 beep. That person didn't get out the way. You hit that person. You get out of your car immediately. I don't care what cop is chasing you, what's going on. It's not like, you're running from active gunfire. He started driving through that parade before there was even any bullet shot at him. It's not like you're running from a mob with, torches on fire and they're going to yank you out the car if they get, no. You got into some petty argument. You knew the police was on their way. There was many other routes you could have taken. When you look at that map, there's many other routes you could have taken. But no, you said, I'm mad. I'm Darrell Brooks. F everybody. F everybody. And so now that is why you are in this situation now. Oh my gosh, Darrell. Let's see. Where are we at now? I got too many windows open here. Hold on a second. Give me a quick second to close out some of these windows because there's way too many. Okay. I this is from. That's a different one. Bear with me. Trying to see which window we are in. We're not in this one. That was yesterday's. Here we go. Am I right? I think this is the one we're in. But where's my Twitter hat up? I'm trying to find my Twitter. Let me see what she said. She smoked his whole argument. Yes, she did. Yes, she did. I'm gonna bring this one down because this is the one we're looking at right now. That way it's easier for me to work through this. And what else did you say? Okay, found it. Yeah, in his mom's truck though. And then when they show him get out, get in the car, he has his little red shirt on. He's like, how do you know that's me? That's his thing to everything. How do you know that's me? No regard for no one, not even himself. Yes. You hear about people running into trees and killing themselves. And when I first was picturing this parade route, because when I was younger, I used to march in the parade. I'm thinking in this downtown streets that we used to march in, their downtown streets are narrow. So it's like they're right in the middle of this narrow street. They really didn't have anywhere to go. Oh my God, it's just insane. It's exactly what that dude said. Insane. Does it say something? No. Let's see. What did she say here?
It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. It's time for Darrell Brooks to stop.
It's crazy that he says he's not a murderer. So then, what does he mean? Yep, that was his ankle in the cross-examination. How you know it was me? How didn't we know it was you, Darrell? How didn't? Like, even with that little blurry picture. Oh, and I want to post that picture where he tried to do another hoax. I'm gonna make a video, hoax 1 and hoax 2. The first one is he tried to say there was a guy with a picture similar. That's you, bro. You have this mustache right here. This is you. I can even see that shape of your eye. This is you. And this is just looking at a picture. People that actually were about to get ran over, that cop that hit your hood, he's seen you. You were seen. There's no way around it. You were seen. Because there was another picture of a white dude or some type of lighter skinned dude in a red car. Looked just like it could be him, but you can see that it's not. So he was trying to use that. I'm like, no. We're not going to play these games. Darrell Brooks. No, I ain't going. Wait, no, I ain't giving no closing argument tomorrow, Judge. Okay, then you'll forfeit that. Then him. You can't force me not to make a closing. This dude he is. Like, when she tells him, oh, well, okay, well, then you don't have to. Then he just gets mad. How you going to tell me I can't do this? No one said that. You said you didn't want to. Crazy boy. This is the same thing.
I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn.
Wow.
While attempting to alert people of their presence.
Well, now you have yourself.
Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make a model of 2010 Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement.
He always try to quickly sneak stuff in there.
Sustained.
Was in fact recalled.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford for those model vehicles.
Sustained. The juror will disregard.
Information.
Oh, wait, I didn't want to show. Let me see if they got it in here. No. Just type his name regular. Or I'm going to just pull it up over here. Okay. Let's take this down. Pop this up. This ain't what I wanted to look for, but I'm going to continue to look for the interrogation.
Varying degrees of injuries to people. The only way to describe it is just pure chaos.
We break down the testimony and the unpredictable moments from day 3 of the Waukesha Parade tragedy trial, where the defendant is representing himself. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Let's talk about day 3 of the Darrell Brooks trial out of Waukesha, Wisconsin. This is the man facing 76 criminal counts for allegedly driving his SUV into a Christmas parade back on November 21st.
It's the car's fault.
This resulted in the deaths of 6 people, injuries to dozens more. And that's why he's been charged with everything from first-degree intentional homicide to first-degree recklessly endangering safety. This is very, very serious here. And what has made this trial, I would say, a bit of a roller coaster and unpredictable, and I would say just a bit of a circus at times, is that Mr. Brooks has chosen to represent himself. We've talked a lot about this already. And as his own attorney, he has not only made arguments and cross-examined witnesses, but he's interrupted the judge. He's been kicked out of the courtroom. He's taken his shirt off in an adjacent room. It is something to see, to say the least. So today is day 3. And the first thing that Brooks does, which maybe was a surprise for many of us, is he apologized.
Jury out. But of course, Mr. Brooks, I need to turn to you first and see if there's any issues you believe the court should address.
Very briefly, I just want to state this for the record that I would like to issue the court an apology from me in regards to my actions last week during the trial. I just want the court to understand it's very emotional right now, not only for just the whole situation of the trial, the families here that have to go through, everything that's going to be involved with the trial, but also my family as well and myself is very, very emotional. But not to excuse my actions, I should carry myself with better respect than that. I wasn't raised that way. And I owe you, Your Honor, and the court an apology. And I'm going to stand up as a man and tell the whole court and you, Your Honor, that I apologize to the bailiffs, that I apologize for my actions. Like I said, that's not how I was raised. I come from a Christian background. My mother did not raise me that way. She did not raise me, to act out of frustration and irritation and anger. And I just wanted everybody to know that I apologize for my actions. And I'm going to try my best to, whatever happens, to conduct myself with respect and with respect to the court. And I just wanted y'all to know that the prosecution, judge, bailiffs, clerks, reporters, everybody.
I'm just confused. So when was he supposed to do all this behaving? Because this is day 3. So all of that just went out the window? Okay.
Audience, everybody here. I just wanted y'all to know that.
Thank you, Mr. Brooks. I do appreciate that.
And the judge accepted this apology. So we were curious. Well, what would happen? Would he be a different person? After all, he's wearing a suit. He's not wearing his prison garb. Last week, he continually insisted on wearing that. So now he's wearing a suit. He's making an apology. Maybe we would have a 180. But then this happened a few minutes later.
Who is you?
Darrell Brooks, the defendant, seated at the table.
Let the record reflect that I do not identify by that name, nor do I know anybody by that name.
Your objection is noted.
Are you a party to this matter in any way? Grounds.
Irrelevant.
Grounds.
Sustained. It's not relevant.
Do you have a claim in this matter?
Objection irrelevant.
Grounds.
Sustained.
Have you read the complaint in this matter?
Objection
Grounds.
irrelevant.
Not relevant. Sustained.
Do you know who the plaintiff is in this matter?
Objection irrelevant.
Grounds.
Sustained.
And again, when anybody refers to Darrell Brooks by his name, he says, I don't identify by that name. I don't know anyone by that name. He keeps on asking witnesses who the plaintiff is in this case, even though it's a criminal case, there's no plaintiff. And overall, this is consistent with what he's been doing, right? It's part of this identification he has as a sovereign citizen, this movement where one doesn't really believe they're under the jurisdiction of the United States government. So it makes the suggestion that he thinks this trial is maybe a scam or it's a conspiracy against him. And look, he's definitely more civilized in court than he was last week. And at the time of this recording, he hasn't been kicked out of court yet, but he's still going to be Darrell Brooks and make these arguments the best that he can. All right, let's get into the substance of the day, though. So the first witness of the day was Detective Thomas Casey from the Waukesha Police Department. And he had finished his testimony, his questioning, I should say, by the state last week. This is somebody who testified that he was 1,000% sure that Brooks was driving that red SUV. Well, the day started with Casey under cross-examination by Brooks. Let's check it out.
Did you observe the vehicle strike anyone when you attempted to stop it?
No, I did not.
Did you see the vehicle strike anybody before it approached you?
No, I did not.
Would it be fair to say that there were hundreds of people present at the time that you attempted to stop the vehicle?
Yes, there were hundreds of people there.
And you saw no one struck by the vehicle?
That is correct.
Did you see if anyone else was, could you see rather, if anyone else was in the vehicle?
I did not see anybody else in the vehicle when it passed my location.
Do you recall there being any tinted windows to the vehicle you attempted to stop?
I do not recall the passenger front or the passenger rear being tinted. I believe that the rear windows on the SUV were tinted.
So it would be fair to say that from your vantage point, you wouldn't be able to see the entire seating of the vehicle you attempted to stop.
Objection, that's a statement.
Grounds.
Overruled. You can answer the question.
Could you re-ask the question, please?
Would it be fair to say that because of the tint to the rear windows that you cannot visibly see the seating of the vehicle that you attempted to stop?
I did not see anybody in the vehicle. I don't think that the tint had any reasons for me not to be able to see him.
So it would be fair to say that you could clearly see the seating of the vehicle you attempted to stop, front, passenger, and back seat.
From the limited view that I had, I thought that I could see it.
So Brooks really spent his time with Casey trying to hit upon his credibility, and even at one point took out Casey's prior testimony from a preliminary hearing that was arguably inconsistent with what he was saying on the stand now. So it appears what Brooks was trying to do is suggest that, did Detective Casey clearly see who was driving the car? What did he even see? And maybe got to give points to Mr. Brooks for asking this line of questions. It's salient points he's making. As an aside, I'll tell you, it was interesting every time the prosecution objected, you hear Brooks shouting grounds, even before they could say what the grounds were, or as they were saying what the grounds for their objection were. At times it made it curious if he was even listening to what the prosecution was saying. And I'll say, I guess he's trying to keep the state on their toes. But from what I could tell, almost always the state's objections were sustained by the judge or allowed, and Brooks had to move on with his questioning. Now, the problem for Brooks is where this testimony went today. Because we heard from several members of law enforcement. These are eyewitnesses to the event. And that includes Officer Sonia Schneider.
You needed to step out of the way so you yourself are not struck. Is that fair to say?
Objection. Leading the witness.
Sustained, please rephrase.
As you stood in the middle of the road facing the vehicle, did you stay in that position?
I did not. I was very concerned the car was going to hit me.
So what did you do?
I jumped out of the way.
Did you make any efforts to interact with the vehicle in any way?
I believe that I had hit out at the car.
Okay. Were you able to see the driver of the car?
I was.
What did you observe about the driver of the car?
It looked to be an African-American male with brown eyes and brown hair.
Did the driver of the SUV react to your presence in any way?
When I observed the driver, he had no expression on his face and he was looking straight ahead as if he was looking straight through me.
And that never changed?
No.
Did the driver of the SUV follow your direction and leave the parade route at Buckley?
No, he did not. As a matter of fact, he appeared to speed up.
Would it be fair to say that that was just a horn that was heard?
No, I don't hear a horn.
You don't hear a horn.
I do not hear a horn.
Can we start that from the beginning?
Sure. For the record, Mr. Brooks.
Objection. I do not consent to being called that name, Your Honor, nor do I identify by that name.
The defendant has asked the video to be stopped. It was stopped at 4 seconds in. He's requested that it be replayed. Are you going to have the whole thing replayed, or do you want it stopped again at 4 seconds?
Maybe around this same point.
I'll wait till you say stop then.
Okay.
We'll make a record of it. Go ahead.
Oh my God!
Pause it. Would it be fair to say that that was not just a horn that was heard on this video?
I will stick with my original answer on that.
So your original answer would be that you did not just hear a horn on this video that was being played.
That's correct.
And that is the problem for Darrell Brooks, because you not only have eyewitness testimony establishing that he was the driver, which, by the way, is so rare to have in criminal cases. I mean, how many times do we cover murder cases without an eyewitness? Here you have multiple eyewitnesses. But his attempts to suggest that he was honking the horn, or not even him, the driver was honking the horn, and maybe, the driver was not trying to hit anyone in the parade, those arguments seem to be shaky at best. So we're going to have to continue to follow this trial to see what happens next, including when Brooks starts presenting his case. And he did indicate today that he intends to call his ex-girlfriend, Erica Patterson, back to the stand. And thanks, everybody, for joining us here on Sidebar. Please subscribe on Apple Podcasts, YouTube, Spotify, wherever you get your podcasts. I'm Jesse Weber. We'll speak to you next time.
Would that be fair to say? Would it be fair to say, do you recall how
Irrelevant
this is a civil
comments.
matter? We haven't addressed subject
All
matter
right, thank you,
jurisdiction yet at all
everyone.
either?
Please be seated. The jury
So
will
we're not gonna
disregard the
address subject
statements
matter?
Mr. Brooks is making about. Thank you. We are in
No,
recess.
you're not rushing me to judgment. I don't care what you're talking about. Telling me to be quiet, or are you asking me?
I'm asking you and advising
Okay,
you.
thank you for correcting that, because don't nobody tell me what to do. Are you asking me to be quiet, or are you telling me to be quiet?
This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
So the plaintiff is an entity.
Correct.
To the best of your knowledge, is an entity a human being?
An entity is an entity. It is not a human being.
Question. It's
Your
called an
Honor,
offer of
this-
proof.
But you still got to understand why this is mind-boggling to me. Like, how try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? The record, I'm not a person, I'm a human being. You always trying to pull some fast maneuvers.
Mr. Brooks,
Miss Judge, Your Honor. Far from an idiot.
they're your witnesses, sir. Mr.
Your
Brooks,
life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
Since you think you know so much, did you know she said she was 18 when I met her? Did you know that?
Would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
That's all, folks.
Okay, so that was the car that he didn't want the jury to see. I know we're going to be in deliberation for quite a while. So when that happens, I will be back and we'll take it from there. For some reason, I just feel like it's not going to take that long. So hopefully it's done today and we'll see what's going on. So I'm going to set up my next live so when it comes on, I could just pop it right up there. So make sure to be looking for that. And once I put it up there, click the notify me so you know that I already just popped in. All right, y'all. Love you guys all. Bye-bye.